Meeting is being recorded. Continue.
Good morning or good afternoon, depending on where you are today. My name is Deborah Masucci. I am not Laura Skillen. I am substituting, although there's no substitute for Laura. We're happy to have all of you here today for a conversation with Jonathan Lux and Wai Pong on mediation East and West. They're going to be talking about the advantages of co-mediation and really talking about it in the context of intercultural mediation. What does that mean for the time and cost to the parties? And can co-mediation help parties emerge and lead to improved discussions and outcomes? I actually lead a global mediation course that I give with Wolfgang von Gumberg, and that's one of the areas that we really impress parties to look at, to, you know, that co-mediation can really help in the discussions, especially in intercultural contexts. And, you know, how does a co-mediator manage simultaneous private sessions? It really means that the co-mediators have to be very in tune with each other, as well as coordinate their activities. So I'm not going to talk much more. I'm going to turn this over to Jonathan Lux and Wai Pong. Just for your information, there are two, everyone will be put on mute during the conversation to begin with. There is a Q&A function. If you put questions in the Q&A function, I will be sure to ask Jonathan and Wai Pong. So I'm now going to turn it over to you gentlemen.
Good. Thank you very much for the kind introduction, and thanks to all of you from all over for attending today. I would have said a pleasure to see you, but unfortunately I can't. Anyway, we're together in spirit. So, co-mediation. At first blush, you may say co-mediation simply an increased expense. Why pay for two when one may generally be enough? Well, it said it takes two to tango. On the other hand, you can mediate alone, but we, Wai Pong and I, will be suggesting that two does often work better. So firstly, as to us, Wai Pong and myself, we think it's a world first, but stand to be corrected, namely a panel that combines members from both the Far East and Europe, offering a co-mediation service for international trade issues. Wai Pong is from Singapore and is a fluent English and Mandarin speaker. I, on the other hand, am from the UK, and I believe I'm fluent in English and also in French and German. We are co-panelists on the Lux mediation panel in the UK and on the LWP panel in Singapore. Now, our thesis is that the center of gravity, and this is really the premise on which this offering is based, that the center of gravity for world trade is moving eastwards, and that there's an increasing volume of trade between Eastern and Western interests. We know that the two biggest economies in the world are respectively US and China, and whatever war of words is currently being engaged in between the two of them, it is inevitable that there will be a substantial volume of trade between these two parts of the world. Now, when it comes to international trade, disputes are endemic, and the question is how best to deal with them so as to preserve rather than irreparably damage the business relationship. If the disputes are resolved by a court, that will likely end up with a judge who may have the same nationality as one of the parties, leaving the other feeling somewhat insecure, playing an away game. If, on the other hand, the dispute is resolved by arbitration, and that has become an increasingly popular means of resolving international commercial disputes, then the rules of many of the large institutional arbitration bodies provide that the arbitrators should be of different nationalities from those of the parties. In other words, almost divorced from the culture of either party. So I think it's exclusively with mediation that there is the possibility via co-mediation to select mediators sharing the cultures of both parties. Now, culture is a big word. The pocket Oxford Dictionary, today I don't have the time to read out from the bigger Oxford Dictionary, says this about culture, and I quote, understanding and manners and tastes, phase of these prevalent at a time or place. What I'd like to do, well, Wai Pong will bring out other aspects of co-mediation, why it's a good idea for other reasons, but I will focus now on the cultural aspect, and I'm indebted to a senior Australian lady mediator for the story I'm about to tell you. And I think this is a brilliant illustration of cultural differences that we can so easily overlook. So the lady in question was appointed as mediator in a major dispute involving, on the one side, a major Australian mining company, and on the other side, an Aboriginal group. And the lady was asked to fly out to the to travel out to the Aboriginal reservation in order to conduct the mediation there. And this involved taking a series of ever smaller aeroplanes out to the far north of Queensland with a final 2 hours on the back of an open truck out to the Aboriginal reservation. Now, when the truck arrived at the gates to the reservation, the lady jumped down to open the gates so that the truck could drive through, and she had jumped back on. And the next thing she heard is that the mediation that she had by then traveled some 8 hours to reach, the mediation was off, cancelled. And she was, of course, very concerned to hear this and managed to discover that she had, of course, inadvertently caused great offence. The Aboriginal custom was that the senior member of the group should be the one to jump down from the truck and open the gates. And she had caused great offence. It was regarded as another instance of white man, or white woman in this case, usurping Aboriginal rights and customs, trampling all over them. And she, of course, which many of us are familiar with, was adopting the Western custom, which is that where there is something physical to be done, the youngest in the group should take it upon themselves to do that, jump down from the truck, open the gates. Of course, once this was explained, there was a lot of effort and diligence applied to explaining carefully the position, and the mediation was then back on, and no doubt with the lady's considerable experience and expertise was successfully resolved. But that illustrates, I think, very well the sort of cultural differences that can exist and that can so easily be overlooked, and which can totally undermine an attempt to mediate unless one is aware or is made aware of the position. So my proposition, and I'll close at this point and pass the baton to Wai Pong, is to say that for two mediators to be steeped in the respective cultures of the disputing parties, it seems to me offers real benefit and can only help in building the rapport and trust which are so essential for a successful mediation. Wai Pong.
Okay, thanks very much, Jonathan, and a very good morning to all of you, or afternoon. I'm in Singapore in the evening now. Deborah, just a sound check. You can hear me, yeah?
Yes, I can.
All right, good. All right, I'm just going to follow up on some of the points that Jonathan has mentioned. So I won't be an echo chamber because I totally agree with him. What I would say is that, let me make a short case for co-mediation. I've done mediation both on a sole basis and on a co-mediation basis. I would say, and I would admit, that my sole mediation has earned the most fees, the best and biggest cases. As far as co-mediation is concerned, I've had the pleasure of co-mediating with retired judges, very learned lawyers, good professional persons in their commercial fields, and I want to mention a lot of newcomers. We have a culture of bringing new people into the mediation scene. So it's been very good experience for me to bring in young people into the mediation scene. So it's against this backdrop of being on my own and earning good fees and having good success on the one side, and then co-mediating with the other people with a different set of pleasures or satisfaction, if you will. And although both work well, what I would say in a nutshell, referring a bit to Orwellian logic, is one mediator good, two mediators better. All right, so that's really my thesis to support Jonathan. Now, on the specifics itself, Jonathan and I, we've worked together for coming to 10 years or more. And we've collaborated on a lot of schemes, and this latest offering is just but one more in our long history of collaboration. And taking on, I think people will ask, oh, two mediators, going to be expensive, right? So what I would say in a nutshell again is that our combined cost is not ×2, it's ×1.5. So referring to the Orwellian logic earlier, one mediator good, two mediator better. You get two for the price of 1.5. That's what we are prepared to offer. All right, and depending on the duration, if it's suitably long, then we can give very, very good discount on travel and living as well, just to make things easier for parties that are multicultural, multinationality. All right, and while intuitively one may say that, okay, even 1.5 is more than one, but our case is that the increased cost may well result or be offset with the shorter time needed for settlement. All right, so is not what it always appears to be at first blush. Now, the second point I want to touch on is how co-mediation can be optimized in our scheme of things. What we would say through our combined experience is that often when we have private session, one party is left on their own. This can have very negative consequences. So in our vision of co-mediation, we will hold contemporaneous private sessions, all right? And there are some combinations of this. We can have one scenario where the counsel for both parties are hot tub in one private session, with the disputing parties hot tub in the other. So we'll split. And we are confident that we can do this solely on the premise that Jonathan and I have worked and collaborated with each other for a long time. And we enjoy a certain telepathy, if you will, so that we're very much on the same wavelength when we do something like that. And of course, from experience, we know that keeping the other party warm, all right, instead of leaving them on their own devices, can be very, very instrumental, because often, especially if the case is very large, a claim is very large, and there are a lot of people, sometimes your private session, that's our experience, can last for a very long time. And that's a real danger. So how to keep the other party occupied, give them opportunities through co-mediation like that, to get them to work out solutions. All this is very consistent with the facilitative approach to mediation, which we are all very familiar with, and especially useful. I mean, in my experience, when I mediated in a case that ran into $120 million, we had 9 counsel in the room at the same time together with their parties. So the logistics of managing so many people, moving them around, was quite a handful for a sole mediator. So speaking from experience, I would say yes, in such cases, having the opportunity to co-mediate would be very useful. And Jonathan touched upon the cultural nuances. Again, that could be very pivotal if you miss it. And I would end by listing out just one more aspect of co-mediation, which I think is very important, is that co-mediation helps parties to better harness their cognitive abilities over the natural bias. What do I mean by that? The first thing to note is we need to identify and be aware that this is a factor. All right, reduction of cognitive abilities for a good solution is an obstacle towards settlement. And the second point following on that is that why this happened in today's very complicated world, parties get confused by too many inputs. All right, there's too many choices and influences from external sources like social media, news. All these have a collective effect to numb their ability to recognize actually very obvious, workable, pragmatic solutions. But because they've lost their cognitive ability, it's very difficult for them to choose. So co-mediation, in my view, and I think I speak for Jonathan, really helps parties to have that clarity. So I'll end my monologue on that note, and I want to kick off to our next segment, which leads to the Q&A. All right. I'll use a case example in this case to sort of tap on all the topics that we are supposed to cover in this webinar. I like to call it the settlement bridge crossing. All right, what do I mean by a settlement bridge crossing? It's my experience that when a dispute which is very big or is very, very personal, if the length and the quantum is allowed to grow to such an extent that they become monolith, that if you leave them to incubate for a long time, they result in owning the disputants. So the disputants wake up every day thinking, how am I going to fight this monolith? They develop a relationship, if you will, with this dispute, never thinking that it will go away because it looms so large. All right, so it's very important to recognize this symptom. And one of the key things we look out for is the incubation period. Every time we see a dispute that comes in, we look at the incubation period. How long is it? Because the longer it is, the more I find it is for parties, they become so insecure and trying to let it go when settlement is in sight. So that's very important for us mediators to recognize. And I feel that in the co-mediation setting, we are much better able to, first of all, let parties recognize this, and secondly, to hold their hands on how to let go. And in this sense, in this example, I want to quote something that Obama said he learned from Nelson Mandela about letting go of his rage, a resentment about imprisonment and forgiveness. And he said he never forget that Nelson Mandela told him, in order to do that, to have closure, it's an act to free not only himself but also the God. To not only free himself but also the God. So it's very important to stress this onto the parties. They're not just doing this for themselves. It's closure for the other party too. So the result of settlement bridge crossing is that what I've seen, and I've discussed this with Jonathan often, we see that when settlement points are reached, the disputants just do an about turn and they go back to their original position. They say they don't want to settle. I mean, when we ask them why, they'll come up with some irrational reason like, oh, the other party is being disrespectful, or they are insincere, all right? Or they may not be able to pay. We know that this is not rooted in reality. They just can't bring themselves to let go. And coming back to this point of Jonathan stressing about cultural differences, different cultures and different nationalities will manifest the same attribute in different ways. So co-mediation plays a very, very important role. First of all, for the co-mediators to discuss amongst themselves what to look out for, and then to actively look out for it during the co-mediation process. So what are the remedies that are appropriate in order to restore their confidence, to cross this bridge of settlement together? I find that, yeah, it's sometimes good to discuss with parties how to move on after settlement. In other words, if it is personal injury, for instance, how to move on with the purchase of prosthetics, how is the rehab program going to take, who are the people to engage, so that all this become crystallized and it becomes easier for the parties to feel that reassurance that it's not just a case of signing it, getting the money, signing the discharge order. You provide them or help them sketch out this roadmap on what to do after that. And often I find this has been a very effective way to help parties cross the bridge in confidence, because otherwise they think that, oh, this monster that I've dealt with for so many years, I can't believe that it's going to go away. In fact, I can't bring myself to let it go. All right. And another way is to tell them not to always think about themselves. Like, for instance, like they may cling on to, we like America first. And one way to tell them is maybe the other party hears it as America alone, not America first. So every culture has a different way to approach this. So my point is that co-mediation model works well in helping parties cross the settlement bridge. And in this way also offer opportunities to incorporate the best practices of both East and West. And Jonathan and I were laughing just now before we started. Should we wear a jacket? Because it's nice to wear a jacket in London. The weather is conducive, but hey, it's quite warm here. So no tie for me today. No tie, just the shirt and the jacket. But we work very well together. So so it's on that note that I think I've spoken enough. I'd like to ask Jonathan to provide some views on what I've just said before we invite questions and answers. Jonathan?
Wai Pong, I think you're absolutely right. There is sometimes a big issue with the dispute has become a way of life, and a party is almost afraid to let it go. This was brought home to me quite acutely during my early years practicing as a mediator. I mean, I had for many years before that acted as a party advocate, acting for one or the other party at a mediation. But quite soon after I started to take mediation appointments, I was instructed in a dispute which involved the Lloyd's names. And, you know, those were painful cases. Many of the Lloyd's names, of course, had started off as extremely wealthy individuals with estates in the south of France, townhouse in Chelsea, etc., Rolls-Royce or two in the garage, and the chauffeur with the peaked cap, and so on. And many of the Lloyd's names, as a result of the litigation, lost absolutely everything. So brought down, at least economically, very considerably. And in this particular case, there was an attempt by a Lloyd's name to attack Lloyd's on certain issues. And I kicked myself for a long time after this mediation for failing to spot a clue right at the beginning. The Lloyd's name arrived with several documents cases full of newspaper clippings telling the full sorry saga of the Lloyd's litigation. And offers were made and counter offers and things seemed to be going in the right direction. And then when it came to closing, there was a stoic refusal. No, we haven't got enough. No, they need to do more. I'm not satisfied with it. And what it came to my mind, was that having lost so much, the Lloyd's name had come to live this dispute, lived and breathed it, got up in the morning to search for what more had been written about it, went to bed at night still thinking about it, that he was simply reluctant to let it go. And I think it is a case where, had I been blessed with a co-mediator more prescient in that respect than I was at the time, maybe that would have been spotted, maybe a strategy could have been developed to deal with that, to focus on perhaps, you know, what were your hobbies before? What sort of other things might you take up after? And refocusing on that sort of thing might well have led to a successful outcome. It was a mediation that failed, and I must say I felt sore about it for a long time afterwards.
You took it a little personally, didn't you?
Well, there were signs there which I'd not picked up on. So I took that as not just a non-settlement, but as something that perhaps could and should have settled had the mediator been more alive to those signals.
Yeah, I quite agree. I mean, it's not something that you normally pick up in mediation lectures or formal instruction, but, you know, crossing the bridge when settlement is really in sight, you could lose everything, not because of any problem with your mediation tactic or technique or whatever. It's just the parties can't bring themselves to let go. So it's, for me, I've always made it a sort of personal crusade to, and I want to bring this issue of, you know, co-mediating, or not really co-mediating, but letting young people or new mediators come in to observe. And with co-mediation, they can see two different approaches, dovetailing with each other for a good outcome. So I think for new people coming into mediation, to be able to join a co-mediation is a very good learning event or experience for them. So yeah, I mean, I just thought I'll bring this up for this webinar to share with our viewers and our listeners on what we feel to be a very wonderful journey to help people resolve their disputes. Mediation is nice, but it can be quite disappointing when you've done 2 days or 3 days worth of negotiations. You got what the parties said they wanted, and then they threaten to, not they threaten, the whole thing threatens to become totally unraveled. for what might at first blush appear to be very, very irrational reasons, but actually there are good reasons. And as long as you are able to address the problem and work with the parties on how they can let go of this thing that they've been obsessing with for so long, that really can turn the key in the final revolution to unlock the door. All right. So on that note, I think we're ready for some questions because I think we've spoken long enough.
So Wai Pong, one of the first questions that came in, and you may have answered the question, but I'm going to put it to you anyway. It's from Ahsan Fatah. He said, how do mediators develop the understanding or telepathy, as you put it, between each other? So the telepathy between the co-mediators, and what can they do if, what can co-mediators do if you don't have that understanding?
Well, I think the fact that Jonathan and I are collaborating, and we only do this after about 10 years of knowing and working with each other, is indicative that co-mediation is not something that you want to sort of jump into it with strangers. I strongly advocate, and I stand to be corrected, I strongly advocate that you should consider very carefully who you want to co-mediate with, especially if the idea or the proposition is to go after big cases. All right. Secondly, I think it'll be a good idea to find a partner whose experience and expertise dovetails into yours rather than to duplicate yours. Because the parties may look at it and say, why am I having two of the same? But we feel that when Jonathan and I come into the table, we bring about 100 years of experience together. He's a very learned lawyer, all right? So he's well able to address legal issues. I come from a very deep commercial background. And so I'm able to address commercial realities. And between us, we are both very, very passionate about access to justice. We want people to have a fair go in resolving their disputes, and that there's no one size fits all. So we believe that co-mediation actually is a good model to actually help people reduce their costs. I know at first blush it seems that, okay, 1.5 is still more than one mediator time, but we're committed with using this model to reduce the time for settlement so that the overall costs don't rise in the final analysis. Jonathan, you got anything to add to that?
Yeah, no, I would agree with your observations. I would say fundamentally it's a question of rapport. So if you've established a rapport and it doesn't come instantly over a period of years, then that's a good solid basis to work in this way with someone. If you haven't, and circumstances force a co-mediation because, for example, it's said that most lawyers can't count. So if there's a case involving a lot of accounting complexity, I have co-mediated cases with an accountant, and we didn't know each other. But then I think it's best to agree that one will be lead co-mediator and the other sort of deputy, because otherwise it could be that issues arise and you don't want to double the number of disputes in existence at the start of the day. So I would say, firstly, if there's the good rapport, that's a solid basis. If not, it may be safe to designate one as lead mediator to ensure that the thing works.
I would add two more points from experience, is that behind the scenes, Jonathan and I argue very, very robustly with each other. It's not that we always agree with each other, but I think that forms part of the chemistry that, because we argue so strenuously and make each other's points, that when we come to an agreement, we know it's built on a foundation of well thought out processes. And the second point is on the co-mediation. I mean, I once co-mediated with the Supreme Court, a retired Supreme Court judge, And I thought, you know, Jonathan coming to this point, whether it would be a lead and a junior, because I obviously felt junior to him. He was nearly 80 years old. But, you know, he said, look, you know, this is a shipping dispute. I'm good at jurisprudence. So, you know, when I come to the private session, I'll hammer them on that. Nobody's going to question me on that, although we're not supposed to be evaluative, but they will ask me and I will address that. But on the commercial side, you take care of that because I know jack about shipping. And that worked extremely well. And I thought, you know, we were actually jointly appointed by the center. So I was quite intimidated at first. But because you know, he insisted that we address the dispute on equal footing, and that worked tremendously well. Okay, next question.
Well, actually, what you brought up is Eugenius Friedi asks, sometimes in local co-mediation, one of the mediators is the good cop and the other the bad cop. How does that work in an international cultural co-mediation? Do you guys do that? I mean, I think it's an American term, but you know, do one of you play the good cop and the other the bad cop?
Not consistently, not consistently, but it is certainly one of the tools and can be used to good effect on occasion. And so certainly, you know, we'd talk and say, this is we think now a good way forward. Let's go in for a bit of this because it's going to prize out useful information. It's going to at the same time help give the necessary reassurance. So yes, it's one of the tools in the armory.
So,
I will echo I would echo what Jonathan said.
So consistent with that question, Maria Kudowska asks, which styles of co-mediation mix best? And what I'm thinking that is asking is whether it's evaluative or facilitative, you know, which style in the spectrum works best?
Jonathan, you want to start?
Okay, I had my moment on the road to Damascus, and I'm not sure that evaluative mediation is such a good thing. Frankly, I think it works best as a facilitative process. Where the borderline is, though, between the two is sometimes quite difficult to define. Because, of course, in asking questions, one may be indicating a preference for a certain viewpoint. But there are other processes, and indeed Wai Pong and I are collaborating on other processes which are very decidedly evaluative. But I don't think mediation works best as an evaluative process. I used to think otherwise. I know that in certain spheres, for example, in the UK, in the maritime world, there seems to be a preference for evaluative mediators. I think, frankly, that's because those concerned don't know yet enough about the wonders of mediation. And it is, of course, very counterintuitive, isn't it? How on earth can it be that a mediator with no coercive powers at all can bring about settlement of a dispute that's been raging for perhaps years? And yet the best data available, which is probably in the UK, the CEDA biennial reports, I think they conclude that approaching 90% of mediations are successful. So it's counterintuitive. How can that happen without having any coercive powers? But it does.
So keeping in mind that the two of you work together as co-mediators, in the chance that you were working with somebody else as a co-mediator, can you give some experiences where you felt that the co-mediator that you're working with had become a liability?
Wai Pong, to you. I'm sure not the Supreme Court judge.
My experience is that we usually call each other up, you know, in the days before the event, and we will talk about the case, and we will map out a sort of strategy and agree, you know, we will assign work to each other. So it's not my experience that, you know, but of course all that is very theoretical. Once you enter the room, tension comes on. It's no longer a training exercise, you know, it's for real, the stakes are real. Then of course you get to see how your co-mediator performs under pressure. But my experience is no, that he has often, well, I would say 90% of the time he has worked quite well. But I just want to go back to the earlier question about which works best. If you don't mind, my experience is that facilitative mediation is a very good icebreaker. In other words, when you start, it's always very good to use that. And for the most part, it works quite well. But there comes a time where you may find that being evaluative is useful. I give you an example. I once mediated in a very large personal injury it was a lawsuit, all right, that went on for years, and they couldn't, it was taking a long time, and then they said, let's try, in fact the trial judge said, why don't you try mediation? And that's how they came to me. And it lasted for 2 days when and this guy, he is a ship's engineer who lost his arms. And he kept referring to me as, you know, captain, you are my captain. And I said, no, I'm not your captain. I'm your mediator. I'm here to help you find a solution. But he kept referring me to captain. But in the end, just coming back to this bridge settlement, crossing it, I managed to get the amount that he said he would settle for, a little bit less than the original claim. But then, yeah, he said, no, I want the original claim. You know, I'm not happy. They're disrespectful. And that was when I decided I needed to be evaluative. So I adjourned the session and I called for, I asked the other side not to discharge me. And then I said, let me buy you dinner. And at the dinner, I said, what happened back there? You know, he said, oh, Captain, they're being disrespectful. I said, no, I don't accept that. I mean, I put myself on the line. I said, I'm no longer a mediator. I'm your captain now, all right? I'm talking to you. I don't buy that, you know, that's BS. You told me you will accept and now you say you won't. All right, what's the story? And after that, we explored, you know, the insecurity behind letting go. And then he asked me, what would you do? What would you do, Captain? I say, I speak to you now as your captain. I'm no longer your mediator, all right? I think you should take it because in English, they have this saying, a bird in hand is worth two in the bush. You have this amount to let you go on, all right? You can start working on your prosthetics. You can start working on your rehab. You have a plan, all right? If you don't take it, and I'm sure you go back to court, you'll win because no judge will look unsympathetically at you. But it may take another year and then appeal. I say, I'll be very blunt with you as a captain. You may die, you know. You get your day in court, but you may die or your life may be shortened because you're not a young man. All right. So you have to decide for yourself which is better. Get the money now, work on the rehab plan, and spend more time with your family in a meaningful way, or go back to court, fight it out. Take your chances with your life, with your future. And I said, don't tell me what you want to do now. Sleep over it. Tomorrow you call me again. The next day he called me. First thing in the morning, he said, yeah, I woke up, the birds were singing. You're right, the bird in hand is worth two in the bush. I'll take the settlement. So sometimes I feel as a mediator, you have to sort of stick your neck out a bit. I know we're all trained to be facilitative, and we can play very safe, and I could have just let it go. But in a sense, I felt, you know, I needed to help him because he had lost part of that cognitive ability to see the solution, and he was overwhelmed with his emotions, and I didn't think that the facilitative approach would have helped. I needed to be tough with him as his captain. So I don't advocate everybody do that. All right, I'm not saying everybody should do that, but as mediators, we need to be sensitive to the occasion. And I think I would have been helped greatly if I had a co-mediator like Jonathan beside me, because we would have taken a decision together. I would have felt more comforted going out on a limb the way I did. You felt lonely. You felt lonely doing that, you know. I mean, I am I'm being a bit personal. I really would have appreciated co-mediating in a tough crossing the bridge situation like that, you know. Okay.
Okay, so this is I think might be a difficult question, but maybe not. Manahan Kanafi asks, have you ever been in a hybrid meet-arb co-mediation process? And how does it differ from a sole mediator meet-arb process?
So there, of course, we're aware of MEDARB, but is the questioner talking about a MEDARB where it's the same person acting as mediator and arbitrator? Because that I have a problem with. I mean, of course, if it's ARB MEDARB or and it's two different people, arbitrator and mediator, no issue. And then the mediation is in fact a discrete component, which, you know, would be dealt with as any other mediation. You'd be looking at, does it make sense here to have co-mediation, or will one mediator be good enough? So I'm not sure what the hybrid aspect brings to this in a sense. Maybe I've missed something. Wai Pong, what do you think?
Yeah, I'm in agreement with you. I mean, our orthodox approach to this, in fact, we call it ARB MEDARB because you must start off with a dispute first. Yeah. It needs to be arbitrated, then it is state, and then it goes into mediation. So I would agree totally with Jonathan that if the composition of the tribunal is different from the mediator, whether it's sole or co-mediator, I think that's fine. You know, they can go ahead, steam on, try and find a solution. Perhaps with co-mediation, you may be better disposed to slice and dice the dispute so that we can cut off a major part of the dispute, leaving only the ones that cannot be mediated to be adjudicated back to the arbitration tribunal. But I would say, yeah, I mean, I'm still an advocate for co-mediation simply because I think it sort of fertilizes the ground better for settlement. So I mean, I still stand by our belief that co-mediation is actually a good solution. But if the parties want sole mediator, that's fine. And the processes are really quite separate from arbitration. I would end by saying I think it's unwise to have the arbitrator to also be the mediator, because that makes for a very complex patchwork of decision making.
Before you go, Jonathan, Manakan actually clarified, and he said he's more interested in MEDARB, where the parties decide to let the mediator make a binding award.
Well, that may be slightly different again, because then what the parties have in effect said is we'll give our best stab at mediation, but if we've been unable through that facilitative process to come to an agreement, then we don't want to go back to court come what may. So let the mediator put on a different hat and, sitting as arbitrator, make an award.
Right.
That's okay. Of course, the parties will have been advised by their lawyers that having switched hats, the then arbitrator will have in mind lots more than a typical arbitrator will have, because all sorts of highly privileged information will no doubt have been disclosed during the mediation phase. But if the parties have expressly agreed that, I don't see a problem. And then, of course, there could be a bit of an issue, I guess, in theory, because if it's a co-mediated case where the two co-mediators are then to become arbitrators, you know, trust the lawyer to find a difficulty. What if once they have become arbitrators, they disagree on the outcome? Then you're in a real pickle. Does that mean you should have 3 co-mediators in that case, so that the decision of any 2 of the 3 arbitrators would apply? You know, I mean, yes, in theory, there could be that difficulty, I can see.
So I'll just give you an anecdote that I heard recently, where under some Chinese arbitration structure, the arbitrators are appointed. There's 3 arbitrators, and under their rules, they ask the party at the beginning whether they want to mediate. And if the parties want mediation, the arbitrators then become mediators. But what they do is one person actually does all of the talking for the panel, and the entire panel is in the room all the time. So it's every arbitrator hears the same thing every other person hears. So maybe that ameliorates the privacy issues too.
Not so sure. I do know that the Chinese have a somewhat different idea of mediation. I am on several Chinese panels, and it is a bit different. So I'm not criticizing, and it goes with the sort of corpus of law that you have in the particular place, what the parties, what's the basis of their contract. But for me, as a Western lawyer, I struggle certainly with the idea of the same person fulfilling the role of mediator arbitrator, if it's to be a full arbitration. If it's just to round off a failed mediation phase, may be different.
Yeah, I agree with Jonathan.
So, I think an easy question, do you have any recommendations on for books on co-mediation?
I think the best lesson is to be learned in the field.
Maybe you should write the book.
Yeah.
So Alden Tan says, thank you, Jonathan and Wai Pong. Wai Pong mentioned about counseling the parties to not just think about themselves. Could you share some tips on how to convince parties not to think about just themselves?
Okay, Jonathan, you want me to take that?
I'll tell you what, I've got one observation on it, and it reminds me of many of you will have heard the story of the apocryphal orange, where in fact the parties' interests can be catered for from the same commodity. In a court case, one party would be awarded the orange, the other party would lose the orange. In the mediation, the skilled mediator discovers that one wants the fruit of the orange to make orange juice and the other the rind to make marmalade. So if you're shutting your eyes to that, you're actually harming your own interests. So that's a starting point for looking beyond your own narrowly construed interests.
Do you want to add anything, Wai Pong?
Yeah, I think it's very common for parties when they come into a room, especially if there's a lot at stake, to only look at their own sheet. All right, and sometimes they will say things like, I'll give you an example. Once I was booked for a 2-day mediation, very big case, and these parties have been, engaged in an arbitration for 3 years without any traction. That's why they tried mediation. And 1.5 hours into the introduction, one party stood up and said, "We are leaving. This is BS. It's not going anywhere. The other party is insincere. We're going home. It's pointless. We're so far apart, more than $100 million. What's the point?" All right. This is a very dangerous situation where the mediator can lose I won't say lose control, but the whole thing can go pear-shaped very, very quickly, and the tensions, if you allow them to escalate. So what I did was I called for a private session. I called them up and I said, "Look, it's very early in the day. I can hear that you are very focused on yourself, and you want early closure. But this is a very, very complex problem. I mean, look at the bundles you asked me to read, and the other side, 2 boxes. I charge you quite a lot just to read, to understand the case. I've got 2 days to explore options. I think you're selling yourself short, by walking away. There are a lot of things to be discussed. By the way, you paid me for 2 days. I'm not going to pay you. I'm not going to give you anything back. And I've got good food. I've got good food. We should eat together. You should give yourself the fullness of time to explore, rather than to shortchange yourself by walking away. I would really, encourage you to spend a little bit more time. At least at the end of today, maybe it will be a better time, because we haven't even got through the opening statements, in fullness, and you're thinking of walking away. So be fair to yourself. Be fair to yourself. And you know the playbook so well on both sides. Here's an opportunity to go outside of the adjudication process into a totally new realm, where I will help you as a mediator. I'm not your judge, and I'm really good at this. Trust me, I'm really good at this. I can make it work for you. Just give yourself the chance. So in that way, it helped them to relax, I think, in that case. Got them back into the room. And yeah, at the end of the second day, we settled. And they were very appreciative. They came up to me and they said, we never thought you would do it. The gap was so far. But I think one of the things that shines through in every mediation that I've done is that, if you are really sincere and you put a lot of work, into convincing the parties that you really have no interest in either party winning, but that you're really sincere in getting a solution that works for both of them, it comes true. It shines through. People can sense it. There's no hiding it. And when they see that you're working so hard, they, quite apart from all the encouragement, they feel a bit inspired that, you are devoting so much of your energy to making it work. So these are some of the tips I would offer, as a means to steer people away from focusing on their own sheet to look at others. And then, of course, you can drop anecdotes like, Obama talking about Mandela and all that. Sounds very nice. So, yeah, I think in the mediator's toolkit, you need to have an armory of this kind of things too. And you need to anticipate that, yeah, parties will sort of jump and, want to jump ship and get off the gangway. Maybe they're also testing you. So you need to be ready. You need to be ready. And you cannot appear shocked. You need to be very calm.
I agree with that. Debbie, am I right in understanding that we're about to run out of time?
Yes, but there's one more question that I'd like you to address, if you can do it. Okay, it's assuming that you have 2 separate caucus sessions and that are going on concurrently. What tools, if any, do you use to preserve confidentiality?
Well, each mediator, so 2 concurrent caucus sessions, each mediator will respect the confidentiality as between the 2 rooms, but of course will share with his or her co-mediator what was learned in each room. So the 2 co-mediators must of course share what has come out of each of those sessions to draw conclusions as to how to drive the process forward. But absolutely, what one has learned in one room must not be disclosed in the other room.
So that's one of the ground rules that you set before you even start the mediation. That that you as co-mediators, the parties understand that you're going to be able to share information between you.
Oh, absolutely. There may be, and that's why I hesitated at the beginning. I used to be a member of the JAMS International Panel, and I shadowed some of the big name US mediators. And I was surprised in one case, I must say, and it was a retired senior US judge who was disclosing in the second caucus some confidential information he had learned in the first caucus. And I tapped him on the shoulder between sessions and asked for a private word and expressed surprise at this. And he said, oh, well, in New York, we've moved on a bit. We are a bit more flexible about some of this stuff. Personally, I view the confidentiality issue as sacrosanct. You do not blow confidentiality, is my view. But of course, you have to share everything that you learn with your co-mediator, because otherwise it's not true co-mediation.
Wai Pong, do you want to add anything?
Yeah, I mean, for myself, if I'm co-mediating with somebody for the first time, I won't risk having separate caucuses. I will do it together. Okay. But I'll readily do with Jonathan because we enjoy a long history of collaborating together. There's a confidence between us that we will cover each other's backs, and that the sum of our joint efforts. Actually, 1 + 1 is more than 2. That's my belief. So yeah, I will be very contextual in answering that. Doing separate caucuses, I won't attempt it with someone I'm not familiar with.
Well, thank you, gentlemen, very much. I think this was a very engaging discussion, and it gives everybody more food for thought. And hopefully, after listening to this, more people will use co-mediation. And one other thought that did come to mind is that one of the participants asked about the mentoring program for co-mediation. So maybe you could, publicize something about how you mentor younger mediators in the field and what opportunities are open for them. But that's something that you can provide at a later date. But thank you so much. It was a very engaging discussion, and have a great day.
Thank you.
Thank you, Debbie.
Thanks, Wai Pong.
Thanks, Jonathan.
Thanks.
Okay. Bye-bye.
Bye.
Bye.